Hi there. In this video, we'll have a quick primer on construction law. A couple of disclaimers here. I'm not a lawyer for sure. I'm not an attorney. And construction law is a huge topic. There are people picking their careers to be legal construction claim attorneys and many ways of working in this area. So it's not just to cover it in a quick primer like that. But I think it's important in this course to learn about very basics of construction law. So when you read the contract, you will understand from where it comes. You will understand the spirit behind it, the basis of the contracts. Very minimal knowledge. Like you need to know very minimal knowledge of how the car works. So when you drive the car, when you have issues, you will know how to deal with it without the need to consult with a specialist for small problems, right? So, and dealing with contracts, you need to know you need to understand the basics of contracts and law before you commit to engineers and contractors and subcontractors. So that's the reason behind covering this topic in such a quick listen video like that. So just wanted to put these disclaimers up before moving into this lesson here. So we'll learn about the different types of law that apply to construction. We'll learn about the requirements for having a valid contract and what happens when it's breached and the damages that can occur of that and remedies for it. And also understand the principles of something called tort law. So what are the types of law? Tort law is one of them, but the first one is contract law. So when you deal in construction, you'll deal a lot with contract law because you constructing projects based on contracts are formed, and if you are in breach of a contract, there will be consequences to that. There's the tort law, which is a public law that governs how to react to incidents that will cause liabilities or injuries or to other people's rights. And then there are statutes and regulations. So like state legislators and federal legislators will create these statutes and laws to be applied in different industries, including construction. And then there is the common, or what we call the precedent law. So it's basically a set of rules that judges would look at by looking at the previous cases similar to this case that's being handled and the suit that's being judged. So they will look at in the history and the libraries of cases, and they will try to match the new one to an old one. And then if there is a judgment that have been made over for a previous case out of respect and being validated always and vetted, typically the new case decision will follow the old case decision. And that's called the precedent law. Now, the next thing we need to learn about is what forms a valid contract. First, there should be an offer. One party have to offer a version of the contract. And then there should be an acceptance of that offer from the other party. There should be consideration, means that there should be some kind of exchange for in return of a performance. So if you're going to do that, I will give you this in return. It can be monetary value, it can be services in return. So there should be some kind of give and take. That's the meaning of consideration. Capacity is the fourth condition. So the party who's getting into a contract, any one of the two parties or three parties, how many parties are involved in that, are legally capable of getting into such a legal interaction. So like minors cannot go into a contract. Or people who don't have the mental capacity can get into contracts. And then the last thing is authority, especially when you deal with companies. So not anyone in the company can make the company go into a contract. There are the officers of the organization who will commit this organization to a contract. So 5 things: offer, acceptance, consideration, capacity, and authority. Now, when you offer a contract, it demonstrates the expression of willingness to contract in certain terms. So, if you offer a contract, this is showing a commitment. And if this offer is accepted, you're legally binded to respect your offer that you made. And that's an example of very applicable example is responding to RFPs or bids. So when you submit a bid, when you submit a proposal as a response to RFP, request for proposals, if this proposal or bid got accepted, you are binding by law to fulfill your proposal, what you submitted for. And this is why we'll cover bid bonds. We'll learn about bid bonds. And the basis for it is basically that you offered a bid or proposal and it got accepted, so you committed to it. This offer or proposal will be nullified if it's being canceled or overridden by a counteroffer. So when you have a counteroffer, then this will invalidate the offer you submit. So you're kind of off the hook, and the other party now is on the hook because of their counteroffer. When you accept an offer, it can be like a direct acceptance, and you have to have that direct acceptance. But on the other side, when you provide a direct acceptance, you cannot say I was joking, right? I was making a joke, I accepted that based on a joke. If you're following a common course of conduct, you say I accepted in a setting that's relaxed, not pressure on you. You cannot say I was joking. You said it, you committed, or you responded to email, you cannot say it is a joke because it's following the course of conduct. Now, contracts can be formed orally, so you can accept a contract orally or offer it also orally. It doesn't have to be written, but of course it's a good practice to write things, to put things in writing. So, but the condition here that when you provide the offer orally, it has to be clearly, all the terms of the contract needs to be clearly provided in this way and established. The parties need to demonstrate intention to be bound by these terms. When you say I agree to this contract where I will blah 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 blah, this is now a contract that's binding. For public sector contracting, the laws that govern that, they make it very difficult to commit the government to oral contracts. So whoever officer in the county or the city is permitted to do contracts, they're limited by oral contracts. They have to make it in writing. And also another thing is the statute of fraud mandates that a certain type of contracts need to be written. So especially these contracts that will expand beyond a year, because expanding beyond a year, that's indication of the size, complexity that cannot be communicated sufficiently using in an oral fashion. So let's see an implication of that, a case study. So Trident versus Austin. So that was a Navy facility, and Austin here was a general contractor proposing for this Navy project, and Trident was as a steel supplier and erector that provided quote of $5.2 million to be included in the proposal submitted by Austin, or the bid of Austin. Austin won the bid, but Austin didn't award this package to Trident. They actually awarded it to others. So Trident kind of went to the court and had a suit. And the idea is I submitted a proposal, it was included in this bid, and my numbers are there. They won the bid, I also part of that. But the point here is there was no direct acceptance of the code by Austin. They included it, but they didn't say I accept. So there was no oral, there was no that documented oral or commitment from Austin to that, and the case was dismissed. So that's very critical when you deal with contractors. You have to be careful about committing to. If you commit, then this is a commitment. So of course, ethically, if Austin used Trident's offer or numbers in their bid, they should commit ethically to Trident, but legally, they didn't commit orally and commit to accept that offer. They didn't make it a formal contract, so they got away with it. Another principle here, legal principle, is promissory estoppel and detrimental reliance. It's kind of related to the case that we covered before, but basically here, promissory estoppel is the protection of a party who is relying on someone else's action. So like subcontractors relying on the GC winning a project. But the general elements of that, to justify that protection, you need to have a promise from the party to another. So the party that's being protected has to have this promise from the other party. There need to be reasonably expected to induce the action. So there would need to be reasonableness expectation, like 50%, like a big chance that this promise will be feasible to achieve. And also there should be detrimental reliance, and meaning here that I'm relying on your action, and this reliance is detrimental to my business. I'm committing my business to my status and my life kind of to your promise. So there is damage if you don't fulfill this promise. And then, of course, the law justifies or requires promisor to be bound by that. So depending on the local law, this promissory estoppel can be limited. And a common example of that, like we said, the bids from subcontractors or teaming relationships, which we'll see in design build. So a case here that in a Houston Metro project, this is a design, build, finance, operate, maintain project. So that's kind of a public-private partnership kind of delivery. The proposing team here, Parsons Transportation Group, PTG, included Metroplex Core in the proposal to manage geotechnical and hazardous material work. PTG eventually got awarded the contract, but they did not use MC. MC now sues for the lost profit. So the judge here is looking at, does MC has the right for promissory estoppel or not? And they found that there is the MC has a right for promissory estoppel, the theory. Why is that? Because there was documentation of promise. So the VP of PTG kind of said multiple times that we committed to MC. And this is the point, is this was a kind of a design build project, so the teaming spirit here was very critical, and this is why they said you're part of the team. So kind of it's an indication of a promise that you will be included if we get the project. Also foreseeability of reliance, and the point here is the dependence here is not like Houston Metro would still need to approve the involvement of Metroplex Core into the team. Already they know that MC will involve Metroplex team, Metroplex Core into the team, the project team. So there was it was foreseeable. This promise was foreseeable. And then the detrimental reliance, MC kept a good amount of workforce ready to work on this project, and that causes, showed that reliance, detrimental reliance. So at the end, Metroplex Core MC had the right for these damages here, for this lost profit. Now moving into breach of contract. So now kind of this proposal here between MC and PTG kind of turned into being a contract, and there was damages here. So let's discuss here what type of other damages we can have. So expectation damages. So the award what was reasonably expected from the contract. So it was the case of MC we have seen before. There is the recession damages. So when expectation damages are not available or applicable, award what the damaged party would have had if contract had not existed. So if you cannot claim that you lost profit, at least you will claim what you committed for the project and the damage that happened because of this contract was not materialized. And then the third special one here is the specific performance and injunctive relief. So it's mainly for a very special type of subject, or which is like art. So in this case here, the breaching contract will have to perform its obligations under this contract or stop doing that in some way. So that's not applicable that much in construction. And then quantum merit is award of reasonable sum of money. So kind of regardless of what case of damages you have, like lost profit or damage because of the contract didn't happen, you get awarded what you deserve to. So kind of it has some judgment from the attorney, the judge handling the case. So some key principles about contract damages here. They cannot be speculative. So they need to have some reasonable degree of certainty. So I cannot just claim that, like, cannot leave it open. Cannot make it people speculate what type of damage. It has to be documented and reasonable, not reasonably, kind of with some reasonable degree of certainty. So the contract may impose limitation on what can be claimed, like, for example, liquidated damages. So if you don't provide or finish the project on time, the owner cannot say, this happened, keep throwing receipts on the contractor, and I lost profit and lost revenue. The liquidated damages put a dollar number for every day or every week that the contractor doesn't finish the project on time. So that's a way of limiting the damages. Or you can just say no damages for delays. So you can kind of liquidated damages are equal to zero, or what we call waiver for consequential damages. So what are consequential damages? Consequential damages are big damages that are hard to provide or difficult to predict. They usually involve third party, and it's kind of a domino effect kind of damages. They create substantial amount of financial exposure and liability here if things go wrong. So this is compared to direct damages. So it's always better to waive consequential damages and focus on direct damages. So what are the differences here? For example, direct damage of a project is lost profit, but you cannot claim that this project caused lost profits on other projects. So kind of you see the domino effect here. Or the cost to repair the damage of the project, but you cannot claim damages caused to customers because of damages in the project. So the consequential damages are hard to it's better to avoid. It's better to have it clearly waived in the contract. So switching gears here to one other type of law, which is the tort law. And we cover that. It's the rules concerning and remedies for harms done to people against or affecting the rights. Injurious here actions doesn't mean that they cause physical injury, but it's just the idea of, acting against their rights or taking away some of the rights or obligations. So there are the torts here, the tort law can be applicable in two situations: when it's intentional or it's based on negligence. So intentional means there is intention to do the harm, and the other case here is there is no intention, but still you did the harm, so you're liable here. So it's kind of a quick example here. You're driving a car. If you hate really someone, or you're on a road rage, and you're after someone who, did a bad turn for you, and then you hit the car on purpose, that's intentional tort. But while you're driving and you're not paying attention and checking your phone, and you made an accident, that's a negligence kind of tort. So intentional torts, fraud. You're lying and you're providing misrepresentation of information. Defamation. So you're saying bad things about someone, so they can't sue you for defamation, or you're interfering with a contract that you're not part of. So you're using some kind of power on one party to break or kind of not have a breach in their contracts with a third party. So that's intentional tort. The other negligence-based tort, they need to be proven by proving the following three things. First, duty of care. There should be reasonable duty owed to a party. So when you drive a car, there's reasonable duty to care about those around you, right? And then there should be breach of this duty, like acting carelessly. And then the next thing is proximate cause of injury. So the injury or the damage that happened to the other party would not have occurred without your breach, without you checking the phone. And also there's a direct cause between the breach and the injury. So it's not like you were driving, you were paying, yes, you were checking the phone, you hit a light pole, and then this light pole kind of caused different domino effects, and then at the end hit someone else. It has to be direct causal relationship between your breach of care and the injury that happened. So these three conditions have to be satisfied to prove that there was a tort that was based on negligence. Now, a big part of tort here is the negligence tort that relate to professional negligence. And I'm talking here to mostly students. Students sometimes take it very lightly that, it's a miscalculation, I just typed it wrong in the calculator. But that's carelessness in the eyes of law. And that actually puts you under liability. So it's a big deal if you're not paying attention to your calcs, or you're taking lightly your duty, and I did a mistake in my analysis. No, that's a serious thing as an engineer or as a professional. So the professional negligence here depends on ordinary standard of care. So as an engineer, you would have a standard of care that is expected from you, and it's exercise of that skill and judgment that you have that can be reasonably expected from someone equivalent to you in skills and competence. And also the idea here, no one is expecting perfect results. So that's kind of a balance here. So no one is expecting 100% accuracy in your calcs, but at least you show, caring, standard of care. So you're reacting on base what you know of information available to you. So what proves the standard of care? The judge will call on an expert to come and say, did this person show a standard of care in dealing and doing their engineering services? Another thing is you cannot claim a professional negligence against an engineer or professional and asking for recovering damages that are beyond what was expected of your service. So it's what we call the betterment theory here. So you cannot, this owner cannot ask for recovery of things that were not actually part of the design. You can say that was damaged or was not performed well by the engineer or the professional. Another thing here that we want to highlight about damages and contracts and recovering them is that economic loss doctrine, and which requires that privity of contract is needed to sue a party for economic loss. So if you're claiming that I was damaged because of this party, this is dependent on, you have to have a contract, a visible, clear, formal relationship between you and the party. But it doesn't have to be documented in a contract, because contractual relationship can be created without contracts. So that might be confusing. So, but let's explain it here a little. So this economic loss doctrine is not a universal thing. It depends on which state you are in. And some states actually can challenge that chain of privity and can actually impose that economic loss doctrine without even privity of contract. So the normal case is the privity of contract is, let's say that this equipment supplier lost or they were damaged in a project, so they need to sue someone to recover these damages. So they cannot go to the owner to the court and sue the owner. So they need to first look at what type of contract I have with, what type of privity of contract I have, relationship I have with. They have that relationship with the mechanical sub. It's not even the GC. They have to sue the mechanical sub. And if the damage is caused by the owner, then they need to sue the GC, and then the GC will sue the owner. So kind of that. Or they can join forces and sue the owner together, kind of. but you cannot directly, the equipment supplier, sue the owner right away. So some states find special relationships that allow suits even without contractual privity. So let's see this example here. So that was the U.S. Regarding the Penn Air Control Incorporated versus Bilbro Construction Company. So that was the delivery system here. It was a design build. So Bilbro was a design builder. They had the Alpha, which is one of the Penn Air Control companies. So it was actually Alpha who was damaged here, was involved. And Alpha had a MEP engineer, a sub-consultant. Bilbro had a kind of a prime sub relationship with the architect here, and the architect has a consultant, acoustical consultant. So that was for a Navy facility. And then, like we'll learn in design build, there were performance requirements, and one of the performance requirements was not satisfied, related to the noise in part of the building here. The air handling units, which is a mechanical unit, didn't satisfy the noise requirements. So this is why Bilbro kind of terminated the contract with Alpha out of, they're not satisfying the performance requirements, and sued for correcting the problem. So Alpha was liable here, but then Alpha actually responded by countersuing the architect and its acoustical consultant. Why is that? Because they provided evidence to the court, and the court concluded that that certain designers, specifically here FBPBA, the architect, and Sparling, the acoustical consultant, had shown special relationship with Alpha, although there is no line here between them. There is no contractual privity between them. Why is that? First, the architect here. The architect was actively involved in the MEP design. They provided comments and suggestions and were very hands-on on the design for the system. And even like the subcontract of Alpha with Bilbro required them to perform the MEP requirements per the architect. So that requirement here showed some kind of special privity relationship. And also the consultant was liable because they were always involved, were hired originally to assess that noise problem. So it's not the installer mistake, it's you had someone to check the noise problem. So why you're suing me, or it's not my mistake. And Alpha was thought about as one of the beneficiary because this Sparling company was providing consulting and engineering services to make sure that this noise problem doesn't happen from the beginning. So that's an example of privity relationships, sometimes special kind of relationships the court will create or recognize, and this was one of the cases to prove that. So that was a very, I didn't do the just explanation of construction law, but it was a very quick primer. Again, disclaimer here, if you want to learn more about that, I included links to the cases that were included. Please, don't make any professional decisions based on that. That was mainly for giving you very preliminary understanding of how understanding law is very important if you are an engineer or construction manager making decisions on a project. Of course, always consult with attorney if you're faced with any situation or decisions. So thanks for watching, and I will see you in other videos. Take care of yourself and those around you.